Right, good morning and welcome to this short video clip, mainly for both Purple and Red Group. I had an online session with Purple Group yesterday, and the aim of the session was to talk about parliamentary law making. So this is a short video clip to summarise some of the key facts that we spoke about yesterday. Now, we started by identifying what were the actual topic, so it's to do with parliamentary law making. Now, those of you who have access to the ebook, please remember, if you read chapter 3, it does talk about everything you need to know on parliamentary lawmaking. The first point we made was the fact that Parliament is the supreme law-making body. If you remember from an introduction to law, we spoke about different sources of law. So we have parliamentary law, we have common law, we have EU law and custom. The most important is an Act of Parliament. So how is an Act of Parliament created? Well, first thing you need to know is Parliament is made up of three parts. You've got the House of Commons, the House of Lords, and the monarch, or the Queen. The House of Commons is the elected chamber. The House of Lords, usually made up of hereditary peers and life peers and bishops, is the unelected chamber. The function of the House of Lords is to make sure they check everything that the House of Commons does in terms of creating Acts of Parliament. So do remember the composition of Parliament is the House of Commons, the House of Lords, and the monarch. The monarch normally just signs the bill, which eventually becomes an Act of Parliament. So how is an Act of Parliament created, or what are the basic steps for the creation of an Act of Parliament? Well, the pre-legislative stage, in other words, certain things happen before the bill is introduced in Parliament, and there are two main stages. The first stage is the issuing of a green paper, so the government minister or the government department responsible for the introduction of a piece of law would issue a green paper. So if the green paper is on the environment, then certain members of environmental agencies might be invited and consulted with to see if the law would work for their benefit and so on. So a green paper is a consultative document. After a green paper, we have a white paper, which is a firm proposal of what was stated in the green paper and so on. So the two stages before the bill is introduced into Parliament are green paper, which is a consultative document, and a white paper, which is a firm proposal of a bill that is going to pass through Parliament. Right, so after the pre-legislative stage, you have the first reading. The first reading is simply an announcement of the title of the bill, fairly straightforward, and there's not much that happens after that. Now, from there, we then move on to the second reading, and during the second reading, it's more of a debate about the general principles of the bill. So what will tend to happen is if there are any amendments or any objections, that's all debated and voted upon, and most of the time the Speaker of the House will be able to tell how people are voting. So they say yes or no to amendments and changes. If that doesn't work, then there's a formal vote. Now, during the formal vote, an individual called a teller, T-E-L-L-E-R, would organise the vote and ask MPs to go through one door to say yes and another door to say no, and then the teller then collects the figures and announces it in front of the Speaker and the rest of the MPs. So the second stage is important because the main principles of the bill are debated during the second reading. Now, after the second reading, so far we've got the first reading, the second reading, the next stage, not so much the third reading, but committee stage, where you would have between 16 to 50 MPs, normally representative of their party's majority in Parliament. So if the Conservatives are in power, then you would have probably more Conservative MPs as part of the committee stage. And they scrutinise the bill clause by clause, sentence by sentence, to make sure that everything makes sense, and anybody who reads the eventual act would clearly understand what it's all about. So the committee stage is very important. The members that deal with the case, with the bill, are a subset of Parliament. You only have a smaller group, between 60 16 and 50 MPs. Now, after the committee stage, if there have been any amendments, then that is reported back to Parliament. So that's called the report stage. If there are no amendments, then from the committee stage, it will jump the report stage and go straight to the third reading. But let's assume there are amendments. It will then move to the report stage. So it's reported back to Parliament, they vote upon it again, and once that's completed, the whole process, so there's a third reading. After the third reading, so after report stage, there's the third reading again. That normally wouldn't require any votes because all the tidying up would have been done between committee stage and report stage. So third reading is the nearly final stage, and then after that it goes to the House of Lords and they repeat the whole process again. A bill can normally start either in the House of Commons or the House of Lords, so wherever it starts it will go to the other house and the same process will start again. So first reading, second reading, committee stage, report stage, third reading. Now after that, and before I make another point, it's very important to note that sometimes when a bill is passed from the House of Commons to the House of Lords, the House of Lords will make amendments, it goes back to the House of Commons, then it's sent back to the House of Lords. So that toing and froing of the bill between the two chambers, the House of Lords and the House of Commons, is referred to as ping pong. Eventually it will all be sorted out, and when both parties agree, the royal assent is then given by the Queen. The royal assent is generally a formality, but there have been times many years ago when Queen Anne in particular in 1707 refused to gave the royal assent to the Scottish Militia Bill because she assumed that the Scottish would be unfaithful and mutiny against her. But generally speaking, these days, the royal assent is a formality. So once that's completed, if there's no commencement date, then it will come into effect midnight on the day that it received the royal assent. Otherwise, in the actual bill, which has become an act, there will be a commencement order, and there will be a clear date as to when all of the act will come into being or into effect, or when parts of it will come into effect, and there'll be dates for all of that. So just to quickly summarize then, you have the first reading, the second reading, committee stage, report stage, third reading, and then it passes on to the next chamber and it goes through the whole process again. Right, so that's a brief summary on parliamentary lawmaking. Now, very quickly, if we have a quick think about influences on Parliament, so who influences Parliament? And before that, I've just got to quickly mention a limitation on the House of Lords, because don't forget the House of Lords are quite a powerful house with plenty of expertise. Because they're the unelected chamber, they have limited powers by reason of the Parliaments Act of 1911 and 1949. So those two acts limit the powers of the House of Lords to block any bills coming through from the House of Commons. They may block it up to a year, and then in the next parliamentary session the House of Commons may introduce a bill and then pass the bill without permission from the House of Lords. That seems to have happened only a few times: the War Crimes Act 1991 and the Hunting Act of 2004. So if we move on to influences of Parliament, then very quickly, so how are laws created? Who influences Parliament to make laws? Political influences are a good example. So most parties in their manifesto will make promises as to what they will do when they come into power. So when they do come into power, the question is, will they introduce bills to fulfill their promises? So political influences is one way of Parliament creating laws. The other one is the media and public opinion. Again, in 1991 or prior to 1991, there were loads of dog attacks on younger children and most people in general. So there was a massive outcry for a law to be created. So the Dangerous Dogs Act of 1991 was created to control the attacks on dogs. In other words, certain dogs or certain breeds of dogs had to be muzzled if they were out in public and so on. You also have the Dunblane tragedy where individuals were killed very sadly. So again, tighter gun laws were introduced to stop that sort of thing happening again. So we've got political influences, you've got the media or public opinion. You also have the Law Commission, which is an organisation set up to review and repeal and suggest amendments to the law. So they are quite an important influence on Parliament. Having said that, the disappointing thing is most of their proposals are normally not listened to. You also have pressure groups such as sectional pressure groups, large pressure groups such as the National Union for Farmers. You've also got the British Medical Association and so on, and then you've got cause groups, which are smaller groups such as Fathers for Justice, Greenpeace and so on, and they lobby Parliament to change the law. So these are typical examples of influences that Parliament face in terms of creating laws. And very quickly, one advantage of parliamentary lawmaking is the fact that it's democratic. You've got the House of Commons who are elected. You've also got expertise and so on. Most of the time, if the House of Lords are not able to flesh out the details of an act, they've got authority to delegate. So that's a good thing. The other problem, or a disadvantage, will be undemocratic. It could mean that even though Parliament is, well, the House of Commons are elected, it might be that the House of Lords take over and influence more of the content of a bill. So that makes it undemocratic. It can be complex, so sometimes some acts of Parliament are difficult to understand because there are reams and reams of sections that you have to get through. But that is a quick introduction to parliamentary lawmaking. If you've got any questions, please speak to me either on Microsoft Teams or speak to me directly in the lesson. Otherwise, read chapter 3 of the AS Law textbook, which deals with all these issues. Thank you for watching.